attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first segment in a multi-part lawcast discussing the sections 4A1 and 4A1.5 exemptions. I will start with a broad overview of what the exemptions are. Just like for an issuer, when a shareholder sells or transfers shares, that sale or transfer must either be registered or exempt from registration. The most common exemptions relied upon are Section 4A1 and the Rule 144 safe harbor promulgated under Section 4A1. Section 4A1 provides an exemption for a transaction by a person other than the issuer, underwriter, or dealer. Rule 144 provides a non-exclusive safe harbor for sales under Section 4A1. In other words, if you meet all the requirements under Rule 144, you for sure meet the requirement for the Section 4A1 exemption. In the event that Rule 144 is unavailable, a holder may rely just on Section 4A1. Section 4A2 of the Securities Act provides an exemption for sales by the issuer not involving a public offering. The issuer itself may not rely on Section 4A1, and a selling security holder may not rely on Section 4A2. Case law and the SEC have unilaterally concluded that an affiliate, which is an officer, director, or 10% shareholder, may not rely on Section 4A1. And now remember, a selling shareholder can't rely on Section 4A2. This puts an affiliate into a difficult situation in the event that they want to effectuate a resale of securities. Rule 144 requirements cannot always be satisfied by an affiliate, such as when an affiliate desires to sell securities in a private transaction without a broker-dealer. The court system, recognizing this gap in the statutory regime, developed the Section 4A1.5 exemption. When an affiliate sells a control block of a public company or executes a private transaction of securities, they are in essence relying on Section 4A1.5 as no other exemption would technically be available. Separately, in 2008, the SEC amended Rule 144 to make its use unavailable for the sale of securities initially issued by a shell company or any issuer that has at any time previously been a shell company, unless all the requirements of Rule 144I are met. These requirements include that the issuer is no longer a shell company, is subject to the reporting requirements of the Exchange Act, has been subject to those reporting requirements for 12 months following the time it filed Form 10 information indicating that it was no longer a shell company, which is normally in the form of a Super 8K, and that the issuer is current in all of its Exchange Act reporting requirements. In an effort to gain liquidity in securities of companies that do not meet the Rule 144I requirements because they are currently or formerly a shell company, selling security holders have begun to rely directly on 4A1, disregarding the Rule 144 safe harbor. However, as noted, Section 4A1 is not available for the use by affiliates who must rely on the case law established 4A1.5 exemption. The same series of cases define both the 4A1.5 exemption and 4A1 separate from Rule 144. In the next lawcast in this series, I will discuss the requirements for the use of the Section 4A1 and 4A1.5 exemptions. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.